Welcome to Court Helicopter News, the fourth explainer today, where we are looking for the Employment Act, Chapter 226. How does the law see separation between an employee and employer? There are very many ways the law provides for how an employer can exit employees or how an employee can separate from an employment. So we are dealing with part 5 of termination of and dismissal. We are dealing this episode specifically for termination. We shall deal with the termination on the 5th episode. We start with a termination notice, where the contract is an employee works per day, a casual, there is no notice to be given. At the end of the evening, the job goes. So wewe kama ni mtu wa mjengo, hakuna notice utapewa. 2, where you are paid between 1 day, 7 days, mostly those people from industrial area work for 7 days, then they are paid. The contract, there is no notice required. You go in, you find there is no job, you go away. If it is a month, your salary is being paid monthly, then the law says you must be given a notice of not less than 28 days. Why 28 days? February is normally 28 days. So a notice of not less than 1 month must be issued for you to get to that place. Then we are told that if you fail to give notice, some of you just wake up. You have signed an agreement that says you give a notice of 1 month. You just say, I just feel I don't want to go back to that toxic office. You will have to pay. If you fail to give a 1 month's notice, you will have to pay your employer 1 month's salary. If your employer sacks you without or terminates the contract, not sacking, terminating the contract without a 1 month notice, the employer must pay in lieu of notice. It is called payment in lieu of notice. Then we have what we call termination on account of redundancy. Has your employer said that now we are declaring you a redundant? I'll be very slow on this because most companies are going to be declaring their employees redundant. What does the law say on the law of redundancy? Section 40 provides that an employer shall not terminate a contract of service on account of redundancy unless the employer complies with the following conditions. 1, A, where the employee is a member of a trade union, the employer must notify the union to which the employee is a member and the labor officer in charge of that area. The fastest thing for redundancy, if an employee is in a union, the union must be notified, and 2, the labor officer must be notified. 2, if the employee is not a member of a trade union, trade unions are like COTU, like NAT, like COPET, like all those trade unions. B, if one is not a member of that, the employer must notify the employee personally in writing and also serve a notice to the labor officer. 3, the criteria to determine who goes in redundancy is clearly provided in section 40, subsection C. What does it say? It says the employer has, in the selection of employees to be declared redundant, had due regard, 1, to seniority. Number 2, the seniority in time and to the skill and ability and the reliability of each employee of the particular class of employees affected by the redundancy. So redundancy must take in skill, must take in seniority, must take in those who were employed earlier and those who are employed later. Then it also goes to say the employer must pay all the remaining leave days. The employer must also pay the 1 month's wages in lieu of notice. And lastly, the employer must clear all the pending days for annual leave. Then that is when the concept of redundancy can move there. What about probationary employment? What does section 42 say? Termination on probationary contracts. It says a probationary period shall not be more than 6 months. So anybody who is employed on probation, the maximum is 6 months. After 6 months, if you are employed on probation, you are supposed to be exited, or if you are retained, you become permanent and pensionable. So that is how it is. Remember, previously, the law was that those who are employed on probation don't get any benefit after it has been terminated. The Court of Appeal has settled that question. We shall be dealing with authorities of labor that even if you are employed on probationary terms, you get the same benefits like a person who has been employed on permanent terms. Then how does your employer prove that you have been terminated? Some of you go and you are told by the word of mouth, wewe na watchman, nenda, boss alisema hakutaki hapa. Or your boss walks in and says, you are fired. You hauna kazi hapa. The law does not recognize such. It says, section 43, in any claim arising out of termination of contract, the employer shall be required to prove the reasons for termination, and where the employer fails to do so, the termination shall be deemed to have been unfair termination as provided for in section 647. So the reasons for termination must be given in writing, not on a WhatsApp, not on a text message. You must be in writing. The reasons must be. We shall be dealing with the dismissal shortly. Then, lastly, on this question, can you decide to abandon work without due notice? The law has warned you. I'm addressing the millennials and I'm addressing the Gen Z, where now we have somebody decides, siendi kazi, and that is all. The law of employment binds you to exit formally as you joined formally. Wakili Dan Sanomari has brought you how to live. The next episode, episode 5, deals with section 44. That is what is called summary dismissal. We'll leave it, summary dismissal, a whole episode by its own. 90% of the cases in the employment and labor courts are about summary dismissal. What does summary dismissal mean? Wakili Dan Sanomari, always it being a pleasure telling you, keep rolling. The weekend is about employment and employees. Asante sana.